So once a lawsuit's filed, the plaintiff and defendant have the opportunity to take statements from each party and witnesses. That procedure of taking statements is called a deposition. And what happens there is typically at a lawyer's office or maybe a doctor's office, depending on the witness. And the person is sworn by a court reporter or a stenographer who takes down everything that's written. It can be videotaped. It does not have to be videotaped in the state of Missouri. We do videotape almost all of ours. But it is under oath, and it is just as valuable or just as valid as if somebody was sitting on a witness stand and telling the story. But it just isn't as dramatic of a feel. That doesn't mean it can't be intimidating to the person giving their deposition. And it takes some time to get used to the question and answer format. Most conversations you have with someone, you can ask questions back. You cannot do that in a deposition. You need to answer the questions that's asked, answer it clearly, and then wait for the next one. You don't get to dictate how a deposition goes, and so that giving up of control is very difficult for a party, very difficult for a plaintiff, very difficult for a defendant. So for our office, it does take, we like to get prepared for the depositions with our clients. We want to get them comfortable. We want to get them used to how it works. Swearing in, speaking clearly, speaking slowly so it's all taken down, answering the question that is asked, making sure you understand the question, all those types of things that can create some confusion when a transcript, an actual written form of the deposition is produced. It can be kind of cloudy. Now, the state of Missouri also allows you to proofread your deposition and to make changes on what's called an errata sheet. Now, that is after the deposition, the transcript is produced by the court reporter to the lawyers. If the client wants to, they can come in and they can go over it and say, I didn't mean that there, it should read X, or I actually thought about this and it should read Y. The client will then fill out an errata sheet, sign it under oath, and then that will be attached to the deposition as if it is part of the record under the rules in the state of Missouri. That can create an issue as to why you didn't say it there at the deposition, why you said it now. But for us, we want the truth to be out there, so we'd rather have it attached than not.